Hello, I'd like to share with you some thoughts on early contract review and how to be prepared for disputes, cancellations, terminations, and issues arising under contracts in the context of the economic downturn and crisis that's happening, that we're in, due to the measures that we're all taking globally to combat the coronavirus COVID-19 threat.
Floyd Zadkovich, International Commercial Lawyers.
Typically we are seeing FM being declared in SPAs and confirmation notices for the sale and purchase of various commodities. Buyers typically are seeking to use FM to excuse themselves from taking cargoes. This could be genuine because of issues with the coronavirus, or the cynic says that it may be because of they don't like the price they're having to pay under long-term contracts. FM clauses in SPAs will typically actually expressly talk about epidemic as an excuse for failure to perform. But it also states generally in these clauses that the FM event to be relied upon has to be unforeseeable and beyond the control of the parties. We think it's difficult to say that COVID is unforeseeable now, although I suppose that it could be seen as unforeseeable what measures are being put in place at ports, for example, that would be surprising or different to other ports in respect of the COVID threat. In charter parties, the equivalent of the FM clause is the exceptions clause. It's like an FM light clause. It's not as comprehensive as the FM clause. Generally it won't expressly state that epidemic or pandemic is an exception, an exception event, as you would expect in an FM clause. It also doesn't state expressly that the exception has to be beyond the control of the parties or unforeseeable like FM clauses. But I think in the nature of the list of exceptions, it's almost innate in those events that it lists. So that list is less comprehensive than an FM clause. Acts of God, restraints of rulers, and quarantine restrictions are expressly stated, and so they're the relevant exceptions that might be triggered in the context of COVID. The sorts of obligations that the exceptions clause may excuse or may help owners in respect of is, in this context, owners, if they're finding it difficult to dry dock the ship or have sire inspections, which can then go to maintaining class or the documents requirements of the ship, and therefore insurance. So very serious breaches of owners' obligations could be impacted by that. It is possible that the exceptions clause could protect owners in that regard, though we would note that the exceptions clause is applied in quite a restrictive way by the courts historically. They don't like to use a generic exceptions clause where there's a specific provision and wording agreed between two commercial parties in a clause. So I think owners should be wary of placing too heavy reliance on the exceptions clause. Also, owners could think about whether the exceptions clause can help them if they don't follow charterers' orders to call at a particular port because that port is closed. It seems to me that if the port is closed, then that's probably does fall within the exception. Unsafe port is of course another clause which might be triggered in this scenario, and there has been some debate as to whether or not COVID and the threat of COVID represents an unsafe port. We think probably not, given that the test is that whether the vessel can proceed to use and return from a berth or port without being exposed, or without exposing the vessel or the crew to danger that cannot be avoided without good seamanship or navigation. If you apply a little lateral thinking and say that a good seamanship in this context could be kind of reasonable measures to avoid the COVID infection. So, for example, ensuring that the crew are suitably protected, are washing their hands, been instructed to wash their hands regularly, are using antibacterial wipe regularly. There's social distancing with the onshore crew, onshore stevedores for loading. Then we feel that probably it's not an unsafe port. It wouldn't be found to be an unsafe port. We think that we do need to obviously look at this, can keep an eye on this, because the nature of COVID could change, and indeed ports could put other restrictions in place which would change its position. So finally, the other item that could be affected by the exceptions clause is on the charterer's side is their late redelivery of the ship. So if, for example, the instruction for the last cargo under a charter, whether it be a voyage charter or a time charter, if that last cargo is at a port where discharge is either delayed or indeed prevented because of COVID restrictions, then the charter is in a difficult situation where they have to find alternative discharge port or have a cargo on board at the time of redelivery. The exceptions clause may help charterers there, and also the final voyage clause can also help charterers there in such a circumstance where, assuming those orders are legitimate at the time of giving those orders. So that's a snapshot of the contractual provisions to think about. There's also, of course, the very immediate issue of non-payment. That's a fairly straightforward breach, obviously, under an SPA. Under a charter, if hire isn't paid, then owners have a right of withdrawal of the vessel. That has to be exercised very carefully. There's a lot of case law about that, the wrongful withdrawal of the vessel can leave the owners being in breach. Owners also will want to make sure they can obtain the optimum amount of damages at the time of withdrawal as well. Is that under a common law right as opposed to the contractual right to cancel? So there's a lot to think about, and also if it's just a debt claim, there's a lot of ways to ensure that you or increase your chances of enforcing and securing the monies owed to you. And Floyd Zakovich is doing a series of talks on asset tracing, freezing assets, vessel arrests, liens in that regard. So probably my final message would be, it is important to be prepared for disputes and terminations and an FM exception clauses being triggered or sought to be triggered. If it hasn't been raised, it could well be raised. Be prepared for that. It's always better to be prepared. So I'd recommend a review of your contracts, in particular those contracts which are with counterparts that perhaps you don't have the most harmonious of relationships with, or those contracts which are particularly good value for you and therefore possibly not such good value for your counterparts. Good luck.